All right, so we'll get started on this topic. And like I was just saying before we started recording, this is not a one-size-fits-all guidance. I don't have that to give to you. What we have is the best we can do right now with what's available. It's been a tumultuous political year. We all know that. And we have a new administration. For better or worse, we're here. And things are changing probably as I am speaking right now. Someone's in a room in DC right now discussing how to change what I'm talking about. So it is a moving target, and we're going to try to keep ABC membership updated as best we can. Like Megan said, you'll have a great safety committee who keeps an eye out on these things, and several other members, us included, try to do our best to keep everybody apprised. So just to give you a little bit of landscape for today's presentation, assuming we can, there we go. What we're going to do is talk a little bit about a forecast for what we see things going. Then I'm going to give you the basic legal overview. Some of y'all, if you've attended a webinar at all on this issue or training or read any articles, I'm probably not going to say anything too groundbreaking. Then I'm going to give you an update on where OSHA's at, because they just recently passed some new guidance on that. If you're not aware, definitely need to read that. And at the end, I have some best practices. So there's your roadmap of today's presentation. A lot of clients and folks we talk to have asked about possibility of lawsuits. Can you get sued for COVID issues? Yes. Can you get sued for breathing? Yes. You can be sued for being born. You can be sued for anything. Does that mean you're going to be liable? Probably not. There will be some class action lawsuits. I can almost guarantee it. You'll probably get a notice if you or a loved one been affected by a negligent workplace or a business or something like that. And you all can expect all those lawyer commercials that everybody loves and enjoys so much. Fortunately, in Arkansas, we have a little bit of more proactivity than other states. Claims like negligence would probably be what would be raised through some sort of, this isn't a product defect. Although if the PPE manufacturers, I'm sure will have some type of lawsuit if somebody with an N95 mask contracts it. Can they sue 3M? Sure. But for the most part, businesses operating during the COVID pandemic are going to be immune. In Arkansas, the governor issued an executive order real early. That was helpful for businesses like you all who had to keep operating, keep building going. Is that a silver bullet? No, there are some legal issues with that. How long, whether the governor has the actual authority to issue that. And in a pandemic, the answer is yes. The question is, are we still in a pandemic? How long does a pandemic last? I think you could argue both ways. Of course, I'm a litigator, so that's my job. But I will tell you that our legislature is currently in session, has Senate Bill 17 already filed. It was just sent to committee, and that absolutely has the authority to create an immunity for civil businesses and hospitals, healthcare providers, all those kind of things, frontline workers. There will be civil immunity, most likely in Arkansas, fairly soon. So when will it pass? I don't know. Will the governor's authority last until then? I suspect. And hopefully there aren't too many people trying to file lawsuits, before this stuff is clarified. One thing I'm going to mention right out of the gate is there's a lot of questions about the Emergency Use Authorization Act. That's a federal law. I just want to be very clear. The way these vaccines were created and approved by the FDA was through the Emergency Use Authorization Act. That's a bill that allows the federal government to basically fast track certain things without going through the typical checks and balances, tests, retests, triple test, all those things. And it's limited to, obviously, emergencies. A part of that bill says that something like a vaccine or medication or whatever it might be cannot be forced. So you cannot mandate it. And what that means is it limits the federal government from issuing a vaccine and saying, we're going to roll out the National Guard. You've seen the movies, right? I know y'all have Netflix. So Contagion's been on your feed at least 5,000 times the last year. Where they roll out and people in yellow bubble suits jump out and start jabbing everybody in the arm, and they drag you kicking and screaming into a tent. Next thing you know, you've got a vaccine in your body. That law prohibits the federal government from making it mandatory. That is not what we're talking about today. Okay, so that unless you work for the federal government, I don't see anybody in here I think does. Even if you're a contractor, that's probably still not enough to tie you to the emergency use authorization. So I just want to be clear. Just for an example, here is the Pfizer consent form. Y'all probably can't see it very well, but it says right here, as part of this, communication to read, understood, and agreed to Section 2, release and assignment of the vaccine immunization consent form and vaccine recipient emergency use authorization fact sheet. That fact sheet is attached with these consents. So anybody who's gone in to be vaccinated has received that fact sheet, and in there it says this cannot be mandated. So sometimes employees will come back and say, "Whoa, you told me you can make this mandatory, and this says you can't. You broke the law. I'm suing." No, that's confusion. So you may have that come up. But the other reason I mention it is because there are some legal scholars, which is a broad term, who have opined that because the EUA says it cannot be mandatory, then that alters what's called the employment at will doctrine. And just a little bit of law 101, employment law 101. Unless you have a contract or you're under a collective bargaining agreement, your employment in Arkansas and most states is at will. What that means is your company can fire you at any time for any reason, with or without notice, with or without cause, as long as it's not illegal. Likewise, you, the employee, can quit anytime. You can leave your company hanging high and dry. Oh, you needed me on that work site tomorrow? Yeah, I'll be there. I quit. Don't show up. You can't be sued for that. They quit. It's their right under the employment at will doctrine. So the legal scholars I mentioned have said that termination for refusal to take a mandated vaccine may not fall within the employment at will doctrine because of the EUA's language. I'm not a constitutional scholar. There's like 3 lawyers in America who practice constitutional law, and they all went to Harvard. They will settle this for years to come. In the meantime, I'm going to give you my best advice on whether the employment at will doctrine is amended on this. And at this time, in discussing with my peers at our firm and elsewhere, we do not think that that would hold up in Arkansas. Okay, so every state's going to be different. If y'all got folks in Tennessee, Louisiana, Mississippi, wherever, Missouri, if you've got outside states, check with your local council. That was for the recording. All right, real quick, I will mention just a change to the FFCRA bill. This was passed in December. I'm sure you're all aware by now, but I just throw this out there. Until March 30th, 2021, you may elect to continue offering paid sick leave for COVID. That includes the emergency FMLA leave for COVID. It's voluntary. You do not have to do that, but President Trump, before leaving office, signed this extension, allowing businesses to choose to continue offering it. If you choose to continue offering it, it has to be on the same terms under the same rules as when it was lawfully required in 2020. And you must make sure you have all your documentation or you won't get your tax break. So that's just a quick mention. Anybody have any questions on that? This stuff's been beat to death, I know. Yes, ma'am.
Documentation includes doctor's note saying that they test positive only, or the return to work note as well. We were discussing that last week.
I don't think you have to have a return to work note that I know of. Whatever justified the leave. So a doctor, it may not be a positive test. It might be an order to quarantine due to a close contact.
Okay.
So it need not be that formal.
Well, on the website, it just says, like, a written, it doesn't even say specifically that, which is concerning. It's like anybody can say, this person has to quarantine.
I've seen about 5 doctor's notes. I'm pretty sure somebody's aunt wrote for them.
Yeah.
And you know, it's hard to call somebody a liar in that situation, but we really wanted to. Yeah, we got some really sketchy doctor's notes. You know, doctors are so frustrating. Yeah, they'll scribble something down and you're like, this doesn't answer my question. If you have that in the future, by the way, send them back to their doctor and say, this isn't good enough. Tell us, are you advising this person to quarantine? Because the IRS may come back in 2 years and say, we want our money back. I don't know. So it could be an issue. Just make sure you have some documentation to show that the approved leave, if you get a payroll tax deduction, you can document that for the future. All right. Now to the meat and potatoes. Can you mandate a COVID vaccine? Yes. All right. Have a good day. They may be lawfully required, and we're going to go through a couple of laws. Next up, we're going to go over EEOC and OSHA. But essentially, there was a change last month that came out. But essentially, this stuff has been around from the 2009 guidance on SARS for the flu immunization mandate. So this was, I mentioned that because that guidance came out through the EEOC under President Obama, which current President Biden was part of that administration. So we don't necessarily see this changing. It could, it's different, but right now I don't really see it changing. President Biden came out last week and said he does not think that the vaccine needs to be mandatory. That was really for federal employees. People are reading it to say Biden says don't make it mandatory. Well, frankly, his executive authority stops at your private business and what you do under the legal guidance. So he is not going to make federal civilian employees mandatory, which is, completely opposite of what I thought would happen. But hey, and so the guidance that we have, again, was under 2009. It basically says, yes, you can have a mandatory vaccine without violating the ADA. But last month, the new EEOC came out and said, in order to do so, you, the employer, must establish that the lack of vaccine in your workforce will cause a direct threat. Direct threat is a term of art under the ADA. It's noted a couple areas. So, for instance, for y'all in HR, if you've been around, when an employee says, hey, I hurt my leg wakeboarding this weekend, I needed an accommodation because of my disability, or maybe an applicant comes and says, hey, I'm taking medication, I need to be able to come in late 1 day a week, whatever. Is that accommodation request reasonable? Well, you go through the analysis, and the question is whether granting the accommodation would either constitute an undue burden on your operations, which just means we can't do that, or it would constitute a direct threat to another worker. So you have two people on a scaffolding team. The accommodation request is, I can't be up on there, but I'll watch from the ground. No, that would constitute a direct threat to your coworker. That's not a reasonable accommodation. So then throwing this out last month kind of is a little bit of a curveball, but we have guidance for it. And I think that, so I put, how? They didn't tell us. Classic VC. You need to do this, but we're going to figure out how to do it. And I think that right now, with the surging numbers in Arkansas, at least it's kind of been surging. I don't know if they're waning or not, but it would not be difficult to show that it would constitute a direct threat, especially if you're a contractor or a staffing agency, or you have folks that are on work sites that you can't control, and maybe you're going to be around other people, there's in and out, and egress points, and tight spaces if you're an electrician, whatever it might be. I think you could show that if you choose to mandate a vaccine, that the lack of a vaccine would constitute a direct threat, just because of the high rate of transmission this virus seems to have. And it seems to be, people get it and didn't even know they had it, and then other people are dying from it. It's just, we don't know. So I think you'd be in a fairly safe spot to say, yes, this does constitute a direct threat. Two other issues that will come up is, one, if someone says, hey, I'm glad to get the vaccine, but I can't, I have an underlying health condition. You can go right through that reasonable accommodation analysis I just explained. What is the request? The request is not to get the vaccine. Then is that person going to be an undue burden on your operations? Well, no. But then will they constitute a direct threat to others? And I'm really sorry for this, but I don't know. If everyone else is vaccinated and you have one employee who isn't, does that person create a direct threat to the rest of your workforce? I'm not a scientist. I don't know. And that answer has not been stated. I think you could, because it's what I understand is even though the vaccine helps, you can still contract COVID or various strains of COVID, and the impacts may be harsher or less. I don't know. So this is a little sticking point for you all. If you came here for that answer, sorry, you're going to be disappointed. Another accommodation could be things like telework, allowing them to work remotely. I realize probably most of you all's workforces can't do that. Extra time off. So we had one issue come up where someone came forward and said, hey, I'll get the vaccine, but I know I have this condition and I think it might be a problem. Can I see my doctor? Sure. Well, they can't see me for a month. This doctors are slammed right now on the limited in-person visits. So is it a reasonable accommodation to allow that person to have 30 days to go see the doctor to see if the vaccine would cause some reaction to the physical condition? The EEOC would say, yeah, that's reasonable. I guarantee it. Unless you can show that that's like a key employee and they're the one person that can turn the screw just the right way. Without them, the whole thing's coming down. You can show that, that's an undue burden. If you can't, you probably need to accommodate that. And there's a bazillion hypotheticals where a disability or a physical condition could be raised as a potential accommodation request. So at the end, I'm going to give you a tip, but put a pin in this right here. This is where you need to train your supervisors to understand that if someone mentions something, the whole company's on notice. And so if you and HQ didn't know about it, but it was said in the field and foreman knew, but didn't report it because they thought it was laughable, then you will have violated the ADA and will be subject to civil penalty or a lawsuit by just not going through what's called the interactive process, which is when an employee puts you on notice of potential need for reasonable accommodation. You must then engage them in a dialogue. And if you don't, you broke the law. You could be liable. You at least have to have that interactive process before you can say, no, we can't accommodate that request. That's ADA. That's pretty much, I could spend an hour on the ADA. That's not really what y'all are here for. Does anybody have any questions related to undue burden, direct threat? Yeah.
As a company, though, wouldn't you be making it a lot easier here in the near future for lawsuits from your employees if you mandate the vaccine that has very little testing, and then next year they all start growing a third eye and want to sue you?
That's a great question. I'm going to repeat it for the recording. Would you be exposed to additional liability by choosing to mandate a vaccine that has not really been thoroughly tested because it was passed under the EUA? And to put it, the hypothetical out there, if employees all start growing a third eye next year, would the company be liable? Could they be? Yes. That's why the civil immunity is so important. I mean, if it's going to be Pfizer or one of the pharmaceutical companies who's going to be sued, most likely. Now, the FDA has approved it. So are you negligent for following the government's recommended advice and getting the vaccine? Because it is recommended by the government right now. Governor Hutchinson went on, got his shot live. Biden did the same thing. Never want to see his upper arm again. That was unsightly. So, I mean, could you? Yes, but it would be, I think it would be a tough hill to climb to say you were negligent or reckless or, as the employer choosing to implement this policy. And again, they have the right to refuse it. Employees don't have to take it. They can quit. It's the employment at will doctrine. You don't have to work here, but if you do, you will be vaccinated unless you have an underlying health condition. Or the second one is Title VII's sincerely held religious belief accommodation. This one, I think you're going to be, I haven't had a question yet. So this is more academic, but there are some factions and some faiths that believe things like blood transfusions may send you to hell because of some one scripture, I think, in Leviticus, and not to downplay their beliefs. Supreme Court answered this question years ago whenever they allowed a person in the right mind to choose to not receive a life-saving blood transfusion because of their faith. So you basically choose to die. So the Supreme Court says if it's sincerely held religious belief, you can die over it. You can choose to die, which the laws typically say life is so important, we're going to save it at all costs. And that's a tough thing. This is a dangerous area to wade into too much. So if you have an employee who comes and says, it's against my religion, I'm a Scientologist. No, a Scientologist would be, they'd be all for it, I guess. I don't really know what they believe. If they're a Church of the Latter-day Saint faction that believes that fetus embryos were used in the testing of this vaccination, and I'm against that. So if you stick that in my body, I'm going to hell. If they tell you that, then again, you have to engage in the interactive process to determine, are they yanking my chain because they don't want the vaccine, or do they truly believe that? And so you have to engage in that dialogue. And if they can provide a statement from their minister or faith leader, shaman, whatever it is, that says they've been coming to this congregation for 5 years and we preach this, and here's the scriptural source for it, and this is the tenet of our faith, you will violate Title VII if you say, hey, you got to get the vaccine. And then, even if it was a direct threat to your workforce, that's the ADA analysis, kind of goes out the window. This is a higher burden to show for the employee, the sincerely held religious belief, but if it's shown, they are protected. You cannot force them to take the vaccine, and you cannot terminate. Now, there is something that's not really clear. The guidance says, let me just go ahead and skip ahead, and I'm going to come back to this. Put a pin right there. The guidance says, if an employee chooses not to be vaccinated after you make it you implement a mandatory policy, then you may exclude that employee from the workforce or the work site. Exclude them, not terminate. So then the next question is, can you fire them for refusing the vaccine? Yes, but before you do that, you also have to determine whether there is an accommodation for one of these two factors, or can you exclude them from the work site or the workforce, like to work remotely? Can you offer them part-time work? Can they come in and sweep the shop at night for minimum wage? Can you give them some work to do, kind of like light duty, but it's not light duty? It would be a job modification. Can you provide that? If you can and don't, then the only issue is, does the Emergency Use Authorization Act alter the at-will employment doctrine? See how this all works together really nicely? It's like I thought through it a few times. There's no perfect answer here, but most likely if you can accommodate, I shouldn't use the term accommodate, if you can alter a job to retain someone's employment, then you are mitigating the risk of liability. Let me put it that way. Do you have to? I can't say. The guidance isn't that clear. Should you? That's a matter of opinion. But if you want to mitigate risk and you can alter that person or put them in a position that they wouldn't be around others, then you might want to do that. That's up for you in your workplace to decide if that's something that's possible. The Title VII religious accommodation, again, there is the undue hardship caveat. I failed to mention that earlier. You can terminate that person if their continued presence in their continued role without any possible modification would constitute an undue hardship. That's not a direct threat, though. That's an undue hardship. And it is no small task to show, hey, this person's existence is an undue hardship under the law. We have to terminate it. So there's your legal overview. Current EEOC guidance. So this came out. I told you the 2009 guidance passed, and it was reiterated in 2020, basically reconfirmed for COVID. The EEOC has been manning a Q&A portal for 9 months and it updates, and it has dates for every question. It's very helpful if you're not familiar with that. You definitely need to review the pandemic preparedness in the workplace and the ADA. That's a document, but also the Q&A on their website is really helpful, and it's updated kind of, as we're going along. One thing I don't want to get too much into, but if you're in this area, I'm sure you're wondering, what about medical exams? So typically the Americans with Disabilities Act prohibits a medical inquiry unless it's a business necessity. So you can't go around asking your employees, hey, can you lift 50 pounds? See if you can pick up that rock. I need to know for your job. Unless the job is to frequently or regularly pick up 50 pounds. Hey, can you lift, stand, push, pull, bend, all those things in job descriptions that we've had, and y'all ask us, what are you doing? And this is why we're doing it. If it's a job necessity, you can make a medical exam. Otherwise, you're violating the ADA by asking about a medical inquiry. And that includes, what medications are you taking? Are you, hey, you're really sleepy. Is something wrong with you? You just made a medical inquiry. So you have to be real careful. And it happens every day. It happens. I know. I'm pretty sure I violated it at some point. But medical inquiries for COVID, EEOC has stated that these screening questionnaires, hopefully many of y'all have been using. Do you have a fever? Have you been in contact with anybody who's been diagnosed with COVID? Are you experiencing any of these symptoms? That's a medical inquiry. The EEOC has said that's a business necessity. You're all good there. But there's one caveat. I think it's on the next slide. Oh yeah, there it is. If you're going to have a vaccine administered for your work site or your workforce, whether it's in your office or the job site, this isn't required. But if you can, please use an external third-party medical provider or a vaccine administrator. Go through a pharmacy, go through a clinic. Don't use an in-house nurse or an in-house whatever. If you contract with somebody to just work for a cashing company, sorry, I just, y'all right. If the cashing company says you're going to come work for us for the next 6 months doing vaccines, which I don't know why they would, then you are now prohibited from making medical inquiries. Because whenever they ask for the vaccine, there's a lot of questions, and you have to answer that consent form. And you pull the medical administrator into your company. You're now one entity, and you are going to violate the ADA if you make those medical inquiries. The EEOC has made clear, if you use a third party, if there's a separation, they keep their own records. They get the consent form. That's fine. We send them off site, or they come on site, but it's not us. That's what you want to do. That's just going to, again, mitigate your risk. OSHA, we're all aware of the general duty clause for OSHA. We have to create a safe workplace. I was interviewed by the Arkansas Democrat Gazette a few months ago for an article that I'm sure no one read. And I was explaining, I said, of course, employers are required to provide a safe workplace. She said, really? I was like, yeah, really. It's called the OSHA General Duty Clause. In addition to a bunch of other regulations, but just generally there's a catch-all. You must provide a safe workplace. It's not a choice. It's not a best practice. It's the law. And so when employees are pushing back against vaccines and saying, why are you forcing this on us? We don't want this. I could grow a third eyeball. You don't know enough about it. Don't do this to me. Employers have a very legitimate leg to stand on and say, this is what we're being told is the way to provide a safe workplace. We're not just doing this to pin you to the ground and watch you squirm with glee. That's not what this is about. This is us trying to take the best steps to mitigate a direct threat to you, which happens to be COVID-19. And that's legit. And that duty doesn't go away in a pandemic. And again, the FDA's approved it. OSHA has a vaccine policy that they recommend. You don't have to, it's not mandatory, but anyways, I think that it's a legitimate, at the end, I'm going to tell you, you need to have a discussion with your workforce. You need to communicate with them. If you're going to decide to make it mandatory, and I've helped clients with this. This is not easy. It's not an easy decision because there's a lot of folks out there that don't trust science, don't trust the government, probably don't trust you, definitely don't trust me, and don't want you sticking a needle in their arm. And holding their job and their livelihood over a barrel is it's a big ask. So when you have your communication plan you put together, even if you make it voluntary, you need to have a communication plan. That's something you want to lean on. And I think that that's helped some of the groups that I've helped work out plans like that. Just reiterate, we're kind of, our hands are tied. It's either this or that, and we've picked this. We think this is the best course. Join us or don't. OSHA did come out with new guidance last month. And by last month, I mean like a week and a half ago. The 29th, they revised the 2020 OSHA guidance. If you haven't read that yet, go online. Here's basically the statements that they made with the change. OSHA recommends, not requires yet, recommends, but if you don't follow their recommendations, are you being negligent? Maybe. Conduct a hazard assessment. So they want you to walk through your workforce and say, all right, I'm the big boss. I sit here. Who's next to me? How much does our office interact? Can we cut down on in-person interaction by doing this, or that? Can we send these people home to work remotely? Can we have staggering work schedules? A lot of businesses are contemplating moving to the hotel model of work sites now, for office space at least, where if you need 30 offices, you have a space for 15, and employees rent out a hotel room and they work in the office for 2-3 days a week, and the rest of the time they go home. There's a real chance that could become the new normal for these businesses that have 3,000 IT people, in a tower. First of all, it's going to save them a ton on rentals, but also it's for the pandemic. Now, it could be a fad that fizzles out. I don't know. But if you're not aware of it, look up the hotel model. Those are the kind of things that OSHA wants you to see if you can handle in a hazard assessment. On your job sites, again, electricians, are y'all all huddled in a small room working on the flux capacitor or whatever goes in there, that, the one place where all the wires lead? How long? Can you stagger that time together? Are they wearing masks? Are they not? Is there air? Is there open? That's a hazard assessment. And you have to document that you did it or it didn't happen, okay? You can't just think about it, driving home and say, yeah, I did it. Now, you can, but then when you get back to the office, type up or have someone type up, here's what we think about our potential for hazard. That also goes to establish if you're going to make a mandatory vaccine policy, that hazard assessment will be your justification for proving a direct threat, which you have to do in order to have a mandatory vaccine policy.
For every job site?
Yeah, I mean, it didn't say that. I'm trying to think in the construction industry. Again, this isn't across the board. I think if you've got job sites that are similar, and if it's, I don't know the terminology to tell you, but if you can come up with a standard that would apply across the board and you're comfortable with it, then go with it. Sure. And again, I've already got ahead of number 2, but identify control measures to limit the spread, such as staggering work times, things like that. Adopt policies for employee absences that don't punish workers as a way to encourage potentially infected workers to remain home. I didn't type that up. That's straight out of the guidance. And that just came out a week and a half. I know the construction industry typically doesn't pay for days people don't work. And so sorry if you're hearing it from me for the first time. This isn't a law. This is guidance. OSHA is an administrative agency. They only have so much authority. It ends at Congress. But you all are well aware of the power of OSHA, as well as I am. And if you don't adopt a policy that discourages people to come to work, then you would be in violation of this guidance. Does that mean that they have to be paid? Is paid sick leave the answer? They didn't say that. What does it mean to not punish someone? maybe it doesn't count as it's an excused absence. I would hope sick days already should be excused if you track them excused versus unexcused. Some companies have no fault occurrence policies, which means if you're gone, whether your spouse died and you're out, or you're going to the beach early and anything in between, it's an occurrence. And when you get to 10 occurrences, you're out. Under this, a no fault occurrence attendance policy would probably be in violation of the new OSHA standard if it included days off for COVID. That's about the best I could think of. If y'all have any specific questions that you want to ask me either on the recording or off, I'll be around. Let me know. Ensure that coronavirus policies and procedures are communicated to both English and non-English speaking workers. So we've had some issues with this before. Make sure your posters are up in every language, and they are now making sure that your handbook or your pandemic preparedness policy or whatever you want to call it is communicated in whatever language you have a worker who speaks. And it doesn't say primary or secondary, which sometimes some of the guidance distinguishes between. It just says distributed to both English and non-English speaking workers. So make sure that's addressed. And then the last one has kind of been around, but this is something to focus on. At the end, I'm going to tell you, train your supervisors. If you don't make sure that there aren't some type of protections for workers who complain about COVID issues or safety issues in general, which you should already hopefully have an idea of, just make sure that COVID falls within that, that they cannot be retaliated against for airing those concerns. They would fall under the OSHA whistleblower protections, possibly the ADA. It's hard to say. But if you have an employee who quits because they're being harassed or a sissy or a Biden lover or whatever you want to call them, some derogatory intended name, and they quit, they could say that was a constructive discharge. They couldn't tolerate working there, and they've now lost their employment, and they're going to sue you and probably win if that's really the reason why they quit. So be very careful. Make sure your supervisors, your field folks, and your foremen all are aware. You need to have some type of, again, a policy is the best way. A communication plan really drives it home, and training is the icing on the cake. That's basically all I can give you on that one. Under the old guidance, and this wasn't amended under the new OSHA guidance, face masks are not deemed PPE. That kind of surprised me. So employers are not obliged to provide them. We've had that question back when this all started. Do we have to pay for these? It wasn't answered yet. We said you probably should. If you don't, it could constitute a deduction from their pay, which in this industry, probably most people are making above minimum wage, so it won't really be an issue. But it does trigger some problems. Any questions? I feel like I'm losing the group. All right. Two of y'all shake your head, so that's promising. All right. A question. Go ahead, ma'am.
Sorry, I asked the question.
No, I'm telling y'all, this would be way more enjoyable if y'all interact with me, but I'll talk at you.
Okay, so we have, where I work here in Houston, we had a situation where our office, it was just like wildfire, we all got corona like in 3 days. So about a week later, we had the opportunity to get, after, it had passed, we were okay. A week later, we were offered the vaccine. And we were told by doctors to not get the vaccine, to get the antibodies already.
Yep.
So we're caught in a really weird place and we missed our opportunity. So we're on the back of the list now.
Yep.
So as far as mandating something like that, if someone just got COVID and you're trying to mandate them to get something, how does that work?
It's a great point. That's one of those, should you give them additional time to get vaccinated? Yeah, I think so. Because, I'll be open. My wife went through the same thing. She's a teacher, so she was early. She got her first dose. Our son tested positive for COVID in between. And, if she had tested positive, her doctor said that you not only don't get the second dose, it won't work. And you have to wait 90 days to get it. And that's assuming it's available in 90 days. And
Yeah.
do you go to the back of the line or they catch you up? I don't know. So that's a physical condition, ADA. And is it unreasonable? I think if you terminated them because they wouldn't go get it on the grounds the doctor advised against it, I think that would be silly, but also a potential violation of the ADA. So yeah, I not to tell you what to do or don't do, but I don't know why you would implement it if it's available for your workforce in that window. Great question. Any others? All right, go ahead, sir.
So, with that case where a roofing work being required on the job site, wear a face mask. Is there a category for that we would consider in some instances to be a safety hazard wearing a face mask because of breathe well, et cetera?
Yes. Drafted a memo on this last year for a client with the same issue. And it was an accommodation of the ADA too. It was a safety hazard in this position role, and they said they couldn't breathe. So they got a doctor's note and said they shouldn't have to wear a cloth face mask. So what do? Give them a face shield. Now, if you've seen Andy Reid in the playoffs, I don't know if disability is an issue with those. I think on cold days like today, spotting up and it creates a safety issue, you have to be safe. But there are alternatives, and yeah, if it's a safety issue, even though it's not PPE, that's again, it's still a concern you have to address. And some of these interests compete. Sometimes you have to take the lesser of the evil, and I would rather have us run afoul of some COVID safety OSHA regulation compliance issue than someone really hurt themselves, personally. All right, good questions. So let's say you don't want to go the mandatory route. What are we doing on time? Yes. You don't want to go the mandatory route. A lot of companies are doing incentive plans. You've probably seen some of these in the news. Some of our nursing home clients have been doing this for as soon as the vaccine rolled out in September, October, whenever it was, they were on this quick. Because you got to understand, if you make a policy mandatory and your workers choose in bulk or individually, no, then you may lose some key parts of your workforce. So there can be a cost. A lot of our clients say, well, we're just going to tell them they have to do it, and they're going to do it. And there have been some surprises. And then when you say, you know what, we spoke too fast, never mind, you have just made yourself look really weak. And you've also educated employees, if we can get our way with that, let's get our way with this. So be very cautious. If you pull the trigger on a mandatory vaccine program policy, you need to be prepared to live with the consequences. And nursing homes found out real quick that, at least initially, 50% were going to refuse it. And you know what nursing homes didn't have? 50% of a workforce to replace with. So they were going to have to shut down. Generally, not all. I mean, some do. It just depends. In your industry, maybe you have a huge pool of talent out there. Generally, I know every industry struggles to have good talent, but are they, willing to take a vaccine, and do we want them as an employee? So again, there's a potential consequence for choosing to go the mandatory vaccine route. A lot of companies, when we bring that up in the analysis, they say, who do you think would not take it? And then probably double it. Because there's a lot of quiet folks out there who just aren't going to, for whatever reason. I'll be cautious on details, but I'm very familiar with an anti-vaxxer personally. He will never take the vaccine. He's very educated. He's very smart, very professional. I couldn't disagree with him more, but he's got his points. He's going to stick with them. And if you said, we're terminating you unless you get this vaccine, he'd walk in a heartbeat. And I bet you there are some of those folks in your workforce that you may not realize. Maybe not, but be prepared, because that is kind of the deciding factor. Are we going to lose some folks over this? Maybe it's your 30-year employee who, you had no idea felt that way. They're close to retirement. I ain't getting that vaccine. I don't need this job. I was just working here because I like it. Now I don't like it anymore. You might push that person into retirement. So be very cautious when you pull that trigger, because if you try to go back and say, never mind, there's consequences for that too. On the flip side, if you go with a incentive program to entice employees to get the vaccine and then go mandatory if not enough people do it, there are some pros with that. There are some cons with that. Can you attract more flies with honey? Sure. But again, a lot of people are going to dig their heels in. And then you get to that point where at what percentage of the workforce is it enough? 60, 75, 90, 95? How many people have to get it for the others to be safe, or them to be safe from the others? These are things we don't have answers for, but I've had this conversation a lot. So be cognizant of that as well. The EEOC came out recently and made clear, hey, don't forget about the wellness plan rules. So if you rolled out an incentive for a medical vaccine, that would fall within the EEOC's purview of a wellness program. Those rules have kind of been in place. These 4 were proposed in January. These yellow bullets there under the first line. And it's just kind of a summary of it. But they want to reiterate that make sure that the program has to be designed to promote health and wellness. It cannot be deemed a gateway plan, which is, I guess employers used to do this. I mean, nobody I work with really comes out and tells me at least that, hey, we want to roll this plan out, but it's not to make sure our employees are healthy. It's to make sure we don't have any sick workers. Screen them out, but this is our subterfuge to do that. What do you think? I would tell them that's against the law. Don't do it. But they want to reiterate that, make sure it doesn't read like a gateway plan. Again, there are limitations on medical inquiries already. You have to give notice of the employee's rights, and that means, you have to communicate them what the plan is, what the incentive is, and you also are limited on what incentives you can offer. I didn't break all those out. That's a whole nother discussion. But if you're going to do an incentive plan, make sure you're aware of those issues, because if you promise them the moon, if you promise them a promotion, that's going to go too far. And if you're doing that, I'd like to sign up with your company. I will get the vaccine. Also, some other potential pitfalls that we've kind of had come up are on the wage and hour side. If you're not familiar with wage laws, they require you to recalculate the regular rate of pay for overtime purposes whenever you pay on top of the base rate, any type of non-discretionary bonus, attendance bonus, seniority pay, shift differential, safety awards, incentive plan pay. So if you dangle out a carrot and say employees work hard, and if you get that, you'll get the carrot, then that goes into the overtime pay. And that's just for your hourly non-exempt employees. But I know a lot of y'all have a lot of those. And so if you say we're going to give you $100 bonus if you get vaccinated, we're all pretty much in agreement on the legal side that that would go into the regular rate of pay. And if you didn't recalculate every employee's overtime, that pay period or more, then you would be in violation of the FLSA. We're talking about a few pennies, nickels, dimes per employee, but there are liquidated damages on top of that. And then there are, if you have 100 employees, that adds up. And then you've got the potential for a lawsuit or civil monetary penalties from the DOL. So it's kind of a small pit, but it can cost you. So if you're going to dangle $500 out there, like I know some businesses in Arkansas have done, $500 to a lot of people is a pretty big carrot, grossed up too. And if they take the carrots, then you got to make sure you recalculate the overtime. It could also violate the EEOC wellness plans. So you got to do that analysis. Comparator analysis, I hate to bring this up, this is always an issue. Anytime you offer something to your workforce, you need to make sure you do disparate impact analysis and say, here's, if you offer, $200 to employees who get the vaccine, and statistically speaking, one group of people, whether it's race, age, gender, national origin, disability, veteran status, genetic information, sexual orientation, gender identity, you pick your protected characteristic. If one group of those people are statistically significant in receiving it, and another population of your workforce is statistically insignificant, that's what's called disparate impact. And I'll tell you, there are some issues with that. We've had questions from our clients on specifically age and race. And so then do you then have to say, you know what, we put it out there, thanks to all those, we're going to give it to everybody. Yeah, you may have to. Otherwise, you risk a Title VII disparate impact claim, which is a disparate impact claim for just for clarification. There's no requirement to intend to discriminate. That's called the disparate treatment. I'm going to treat this person differently from this person. These are comparators. I'm going to treat them differently because of their age, race. Disparate impact, there has to be no intent. It's just numbers. And that can be a tough pill to swallow when you're trying to do right by your employees. Say, you know what, we didn't make it mandatory. We paid you $500. We got sued by the DOL, and now this, it can rack up. And then the last thing, the last caveat is a boomerang effect, which we're hearing a lot of marketing firms are coming out on COVID incentive plans and saying, look, you roll this out and say, hey, look how great we are. Go get the vaccine. We're not going to make you. Here's $500. Thinking, great, thank you. I'll take that. In reality, the workers are saying, well, I was going to get it, but now you're having to pay me $500. Something's not right. And your good intentions come back and hit you in the face like a boomerang. So I don't have any empirical data for that. I'm throwing that out there because we've had a lot of conversations with a lot of trade groups and a lot of law firms and a lot of legal arenas over the last 6 months on these plans. And I'd say there's a good bit of belief out there that if you go incentive, that it could, at least for a portion of your workforce, have the opposite effect. So be careful. Any questions on incentive plans? All right. This is my last slide. You guys are really either absorbing this or can't wait to get out on those icy roads. Just a few tips, reminders, okay? This is what I wanted y'all to take away from all this. It's a best practice to encourage sick employees not to come to work. I know that can be contrary to business needs. I'm well aware. I am not naive. We all understand the job needs to get done, and the job needs to get done timely. That said, the guidance makes clear that if you have if any word is spoken or any policy document is written or any intent is made that incentivizes employees to come to work with COVID or COVID symptoms, then that is what could open you up to civil liability in my mind, because if someone were to get it, then what the civil immunity doesn't prohibit is reckless behavior. It can be maybe negligent, but if you're grossly negligent or reckless, which can be established by showing, we all got it. They said, hey, stay home if you're sick. Everybody knows on Don's crew, just joking, Don. Don's crew knows you better be at work. You're going to be, somebody else will show up in your place and you're going to get a call back the next time the job comes available. Or whatever. If that exists, that opens you up to civil liability, not to mention regulatory liability, and frankly, workforce retention. You have to communicate your standards with your employees in all languages. I've already mentioned this. I told you to put a pin in that. When you're rolling this, if you're going to go the mandatory vaccine route, the OSHA general duty clause, the risk hazard analysis, All those things you need to explain to your group. This is why we're doing this. We didn't just do it just because. We've done the risk analysis. We've issued spotted hazards. We don't think we can mitigate the risk through whatever measures. We think that this is necessary to provide a safe workplace, and that's our job. That's our requirement under law. We don't have a choice. Work with us or don't. This is what we're doing. And why? Don't try to shove it down your workforce throat. Nobody likes just being told something like this. You know, try to use kid gloves if you can. I get it. It doesn't work for everybody, but to some it will. Again, train your supervisors. You all got to squash any ridicule, insults, whatever the humiliation jokes, posting funny stickers, you know, putting a Biden 2020 flag on their car, whatever it might be. That would be, if it's done because somebody reported concerns over COVID or related issues, that's going to be whistleblower liability. The OSHA guidance that just came out January 29th said consider, or employers could have an anonymous reporting line. So the old comment box that seems to come and go every 10 years, you know, which people dread because it's usually filled with tasteless jokes and irrelevant stuff where it's the same guy complaining about the same thing and you've already answered him 100 times. You get sick of it. But just by having that comment box available, you have given at least those workers who may have some concerns the opportunity to, you know, report it anonymously. And then if they are ridiculed, harassed, or joked about, then you can at least say, hey, that happened, but we as a company didn't know that they were the reporter. You might not be able to prove it, but it definitely helps. Perform routine environmental cleaning. You all know that. It's nothing new. But what the new guidance also said is if something's time sensitive, then urgent cleaning is required. You can't just wait a day or two. You know, get in there and spray it down as soon as you can. And also in any policy that's related to vaccines or COVID or anything related to your pandemic issues, the new guidance makes very clear, do not distinguish between vaccinated and non-vaccinated workers. If you have an incentive program, you're obviously going to know who's vaccinated and who's not. I think, assuming they come forward for the incentive. If you have a mandatory, you will too. But even if you know through a proper means, again, there's multiple legal issues layered on this statement, but they made very clear, don't categorize them. Don't put a scarlet letter on the folks who are not vaccinated. If you do that, you're probably going to end up with a complaint from OSHA. And could be Title VII, could be ADA, could be whistleblower, anything. Then, if you have any questions after the fact, you're driving home, you're doing your hazard assessment. Oh man, I had this great question for Greg and I robbed him of it. You can email it to me right there. Megan's going to send these slides out, I believe, to everybody who attended. You're welcome to review them. There's nothing too stellar in there, but it might help you recall some of the issues we talked about today. And again, if you hear something that you think is helpful, let Megan or the folks at ABC know. We're all in this together. These are hard decisions. Appreciate you coming out today, and hopefully we shed some light on some of those sticky spots. So thank you.